Thank you very much. So I think we have just enough time for questions.
I have a question about the Alexis about the question. Originally, I come from China, but mainland I do not know much about this historical process in very informative details. I think this topic is very interesting because this topic made me recall another historical event which happened in Europe. That is a formation of English common law. When the French army from the Normandy conquered England in 11th century. And at that time, when the French army from Normandy conquered this island, England, they do not bring the French local law across the strait into England. Some scholars think one of the reasons is after all, the French army, French ruler is as a foreigner to the England, and they would like to avoid more local resistance. So my question about based on such a comparison, and at that time when the Qing government would like to bring the Chinese law across the straits, is there any such consideration of fear about the competition of the two legal systems, the foreign law and the local law?
That's a really interesting question. The short answer is no. The slightly longer answer is that so you know this, the Qing are Manchus, and they're a relatively small minority ruling a large multi-ethnic state. So they're ruling not only what we think of as China, they're also ruling parts of Tibet, they're ruling large parts of Mongolia, they're ruling Xinjiang, the Uyghurs. So they made the deliberate decision that they want that for Chinese people and on the Chinese borders, they were going to use a modified form of the Ming Chinese legal code. Now, the Manchus had a slightly different legal system, though they still used the same code, and the Mongols got their own separate legal code. My theory on this is because most of the diplomatic relations between the Qing state and the Mongols some of them were conducted before the conquest of China, and even the later ones were conducted with a sort of, well, we're all steppes people, we're going to communicate and negotiate like steppes people. When the Qing is dealing with the southern borders, Yunnan, Guizhou, and then eventually Taiwan, they really are adopting a lot of Chinese colonial practice. So that's why, for a while, they adopt the Tusa system with the local chieftains. And when they come to Taiwan, first of all, I know that technically in Chinese law today, all Taiwanese Aborigines are one tribe. There were literally dozens of different tribes, all speaking different languages, all with very different customs. Some had their own writing system, some didn't. And some had strong diplomatic bonds with each other, some were at war with each other. So there was lots of small scale competition, but there wasn't any sort of island-wide legal system they were competing against, except maybe the now two generations old memories of the Dutch. There was also the Ming loyalists who were occupying Taiwan briefly, so there's already some ideas of Chinese law there. And the Ming loyalists, though, were really too busy trying to fight off the Qing to really establish any kind of state with the Aborigines. So I think it's an interesting comparison, but you don't have a strong common law system or an island-wide system to compete with the Chinese system. And so the Manchus, I think, decided to just continue the Chinese practice. It worked for the Ming, it worked for the Tang, and so they were going to make it work for them.
It's in the back.
I have two questions for Hi. I couldn't hear everything from the back, so I hope I understood it correctly. My first question is, do you look at any other cases despite the one that you just discussed between the period of do they refer to other geographical areas? Is the debate on these different instruments of international law in India, is it contained to just India? Or do they look at other regions of the world, like Southeast Asia or Africa?
I can't hear properly. First question was whether there is unequal alliance between.
Very nice.
Sorry, hang on. I was saying, how is that related?
Well, I think there's a whole history of cases, and of course the relation between the Raja of Benares and his unequal alliance and the East India Company is an issue. But since then, the variety of possible subordination relations has changed. So there's a memory of the fact that there were diplomatic relations and treaties in which perhaps the profit might be a bit unequal, but in the end everyone has the impression that there's a sense of reciprocity and recognition. This is somehow manageable in larger extent liberal idea of English international law, but now after 1958 and the Indian mutiny rebellion, first independence movement, however you might call that, the perspective is completely different. So we try to rearrange it. We have centralizing movement, we rearrange administration and all the institutions. And now the Manipur Princess is the third leading case after Baroda and Mysore to get principles of indirect rule, basically, which use argumentations of international law. And this is very twisted. And so there are more cases to this, but what do they have in common? I guess basically that they are not cases before regular courts, but all are military tribunals or what kind of administration bodies, commissions who decide. But what will be found in Westlake's international law also is just the denomination as a regular tribunal. So a part of the story is lost, and that's also a reason why I think that this perspective on the history of international law might be useful. And the second one, well, the reference to other geographical regions in the reasoning, it's very interesting to see that there's lots of reference to European cases, as for example for the cases of the Admiralty courts. There's a lot of reference also to the courts of Admiralty, and so that is
Yes.
Sorry. Thank you. So there are lots of references to the European cases, which is very functional then for the kind of reasoning the barristers are trying to establish. There should be many other cases, but from Africa perhaps, but from the Asian parts, South Asia, but basically it is necessary for this barrister to refer to European cases because this is the legal justification for this moment of mutual recognition in the courtroom or in a courtroom similar situation.
to present time, and you were talking about women going to courts in contemporary times, that you were even personally experiencing these kind of claiming rights by women. And I was wondering if you had some evidence of historical examples of women going to court as well, or if it was just because you were talking about the British working security laws not applying to the Indian context, of course. I was wondering if there were anyway some litigation processes.
I really did try to look for a narrative, focus my story on one case, but I couldn't find. I spent some time in Calcutta archives. I could not come across. It was only with Assam inquiry that what was happening in the plantation for the first time actually came out, because nobody used to go to those plantations. And even today, when they come to the court, it's not easy. If the jurisdiction falls in Delhi, and I have seen it so many times, their language is different. They have a very local language. They don't have transcribers in the courts. And these people come from Assam, taking a loan of like 5,000 rupees from their neighbors to come register a case because they want to find their daughters. But, they don't understand the legal system till date. They're not aware of how to approach the courts. And they don't trust the court system in any case. But I'm still trying to search. Apart from newspaper reports, I couldn't come across much as of yet.
Thank you. Well, it's a question for Gitanjali. Could you clarify? I mean, I thought it was very interesting the way that poverty regimes based on different epistemology were being imposed. But I was just wondering why it was complex in the sense, why couldn't you just take the whole legal structure that was applicable to the church and apply it? I see why it wasn't convenient for locals, of course, but why it wasn't clear? But why was it difficult or confusing from the point of view of colonizers?
Well, in some ways they did take the legal structure of the church, because if you look at a trust, and if you look at how the trust, it does come from certain kinds of theological notions. So, for instance, Christian churches are regulated by trusts. What I do want to say is that even if you take the idea of the church, there is no central authority. So what would they really do? They can't, they can't find the central authority the way you would find the Catholic Church or the Protestant churches or anything else, because the entire tradition is far too diverse and there are far too many questions of, say, hermeneutics or interpretation. So I don't think the church model can be applied.
It's more very interesting discussion. So the next is one, it's not a question, it's just a note. I mean, actually that's a very, I think that kind of serves as a proof for having this kind of concept, because when you were dealing with this kind of adultery case in Taiwan, I think that for a lot of Israelis here in the room, there's a kind of very famous case in Israel with, its name is Maurice Azuelas. This was taken in the mid-90s, and the story is kind of very much of the same, because there's a story of a husband who's suspect of his, I will give you the reference much later. So he's suspect of his wife for quite a long time. That's what he says in quote, for example. So he suspects her to cheat on him, and he's kind of trying to look up and to see whether it's true or not. And then one night he comes back to his home, and then he saw her in a car with another man. So but the story ends very traumatically, because he took to go, and then the neighbor, because the husband asks the neighbor, he's starting a conversation, then he asks whether she's cheating on him, and then the neighbor, which was in her with his wife in the car, who says, yes, we are cheating. I mean, she's having an affair with me. We don't know if that was true or not, but that's the story. And then the husband, he pulls out his gun and killed both of them, if I can recall. But anyway, the case is getting to the Supreme, killing both of them, right? So, okay, but he kills one of them at least, and this case is a murder case, and it reaches all the way to the Supreme Court in Israel, and it's in the mid-90s, and Justice Aaron Barak, that was before appointed as the Chief Justice of the Supreme Court of Israel, has a very famous verdict when it says that when the common Israeli man sees his wife with a stranger guy, then his blood and then his temper is losing his control, and so it's a very it's a very famous and a bad reputation quote of Aaron Barak, but that's kind of a, the scene, the car, the woman with another man, so it's kind of a, the adultery scene, it's kind of a, this is Southeast Asia and this is Israel. And I think there's also writing of, if you're familiar with Elizabeth McCloskey, I think she has a very interesting article also in this kind of the imagination of the Indian women in British India. It's kind of maybe it has some kind of interesting response.
Yeah.
We have time for a couple of more questions. I think we'll go for it.
I've got another question for Verena. Thank you very much for the presentation. My question is a little bit general. So, as I understood, the counsel for the defendant in that case, among his arguments was the claim he tried to overrule the jurisdiction of the British court dealing with the case on the basis of the international legal principles. So I just wonder, was there any precedent for him to do in a British court to was a British court's jurisdiction ever quashed in a British court on the basis of some international principles, not on the basis of British law itself? So, yeah.
Well, I think in this memorandum, it's a nice try to test the force of the international law argument, because this is the context of a larger discussion on executive powers and judicial possibilities. And this is an ongoing debate for more than 100 years at that time. And one of the leading cases there would be the case of the High Court judge or Supreme Court judge Elijah Impey in the 1780s, trying to have a stronger power than the Governor General and his council. And after 1958, there's been a whole bunch of legislation trying to fix the powers of each. And this is an ongoing rivalry. So I rather read this as one nice try to have this international law argument in the debate, and to really make a point on the fact that people who are not legally trained should not judge state offenses, because there's legally trained personnel for it, even if it's native personnel. And this is a space of action which is reserved to experts. And magistrates, in that case, are not experts because they are hardly not legally trained. So.
Maybe last question.
Yeah, I'd like to respond to that question. Back to the Privy Council again. There's a bunch of cases, Privy Council cases in the, I'd say, second quarter, approximately, of the 19th century, with names like, with case titles like the Justices of Jamaica, or the Justices of Demerara, or various British colonies, where people raised questions about the jurisdiction of the British court, not necessarily in grounds of international law, but the British had to, from the British internal legal point of view, there had to be some kind of legislation, usually an order of council or something like that, authorizing a British court to be acting outside of Britain. So they did raise those issues, usually the court's jurisdiction, as I said.
But could British statute ever be quashed on the basis of international law in that way?
Right, that's a good question. So that came up with the discussion before with Inga's paper. Personally, I know questions were raised not about British courts jurisdiction, but about British legislative and executive jurisdiction being opposed to international law. So there's a couple of interesting cases which you can read about in the exhibition essays from the 1920s.
Okay, so I think we'll end it here, but maybe our speakers will be happy to answer questions during the break time. And we'll meet again an hour from now.